Special counsel David Weiss has told a judge that he plans to indict Hunter Biden. Weiss's team told U.S. District Judge Maryellen Noreika today of its plan to indict Hunter Biden before September 29th. Judge Noreika set today as a deadline to hear from both sides about how to move forward on both the diversion agreement that would have avoided jail time for Hunter Biden on a felony charge of lying on a federal form when purchasing a firearm. So we wait now to see if Biden's defense team will file anything, but special counsel Weiss's team makes clear in its filing the intention to indict Hunter Biden by September the 29th. Right now, let's talk about this even further with former federal prosecutor and friend of the program, legal analyst here, Doug Burns. He joins me now. Doug, good to see you. You and I have talked about the Hunter Biden case so often. And I'm going to cite something from one of your contemporaries, Andy McCarthy, on a podcast I listened to in the wake of the plea deal that was reached between the DOJ and Hunter Biden's team that blew up in court some weeks back. Andy McCarthy says, I'm paraphrasing here, why didn't the DOJ just indict him in the first place? But now you're looking like that's going to happen before the end of the month. Why do you think they didn't just indict him in the first place?
Well, therein lies, a very, very important point. So, you have two discussions. One is straight up on the merits. Okay, they announced that they plan to indict him. Quick technical in the weeds point. Even though an indictment's not required for a misdemeanor, I know I'm getting in the weeds, you can actually use the indictment process for misdemeanors, but that's separate. We'll assume for the sake of argument, right, arguendo, as we lawyers like to say, that they're going to return some type of felony count. What Andy McCarthy's getting at is brilliant, and that is that the Attorney General of the United States looked everybody in the eye and said that Weiss had independent authority to do whatever he wants. Well, if that's the case, why is he now seeking a more serious charge? Why didn't he seek the more serious charge earlier? And again, I'm not going to definitively conclude that it was because DOJ was directing him, but it's certainly an inference that one could draw, and entirely reasonable to say that now that he is a special counsel, he doesn't specifically answer to DOJ, and that's the reason why he's taking a more serious step.
Okay.
And that's the logical sort of conclusion.
Yeah, because I think it's important for the viewers just to kind of like get them up to speed. So, we all remember that, David Weiss, the U.S. attorney there in Delaware, he didn't have this independent special counsel status. And so he was somewhat, I want to say, pigeonholed there to the jurisdiction of Delaware. And he had to charge crimes that were committed there. And correct me if I'm wrong, but now once he got this special counsel status from Attorney General Merrick Garland, he could look around in any jurisdiction and basically he had so much more power than what he had as just the U.S. attorney looking into this in Delaware, right? Do I have that right?
Right, of course. But it behooves me to, again, critique the Attorney General who looked everybody in the face. And I'm not, anti-Merrick Garland, by the way. He was a good judge and he's a sound lawyer. But, sometimes when you get into that heavy Washington political landscape, he looked everybody in the face and said, if you remember, Andrew, Weiss, does have the authority to bring cases in other jurisdictions. I don't believe that was true, incidentally. But the point is, now that it's very, very surprising. Again, and I know we went over this, but I'll just repeat it. Very surprising that you would pick the same individual to be special counsel who was in a somewhat controversial plea deal, number one. And then number two, the regulations in the Code of Federal Regulations, now famously known to everybody as section, 600.3 of 28 CFR. But the point is, supposed to pick the special counsel from outside the government. They just flat out violated that. I had said that the reason they did that was so they could set up an argument of not cooperating ostensibly with Congress because of an ongoing investigation. But the fact of the matter is there's a lot of things going on here. And the message I'm trying to deliver to your viewers is that, you can't just accept stuff at face value. You got to try to break it down a little bit and say what's really going on here.
Yeah. You know, Doug, was there, I guess, logic behind bringing an indictment sometime soon because what they planned to, indict Hunter Biden on, which we don't know yet what the charges are going to be, that possibly there was, statute of limitations on whatever they had intended to charge, and so they had to get the indictment before those statute of limitations ran out? Is that plausible?
Yes and no. Yes and no. Yes, I read, just as you just reported, and you're right, that the statute of limitations on the gun charge may run in mid-October. No, because it's routine, and I've explained this before, to get on the phone with the defense counsel and say, we want you to extend the statute by 2 months as we consider further. Every defense lawyer on the planet always does that, because if they don't, they'll indict, and you can have further discussions pending. But you're right. I think there's a more important reason, though. This is actually kind of interesting, and it's kind of above my pay grade. It's more of a political analyst's bailiwick. But the fact of the matter is, with the Department of Justice bringing 2 indictments against the former president, setting up the obvious narrative from the right that, going after a political opponent and all of that. So now here comes the counter chess move, which is, well, we're also indicting the president's son. That's what I think is going on. But I'll tell you something else. The news cycles, seems to me, are interesting because something gets out there and then it gets baked in. And then later, if it's different, sometimes there's no accountability from cycle to cycle. So hear me out. They turn around today and they say, we're going to indict him. And you can imagine people walking around legitimately, which is fine. Oh, I heard that. Actually going to charge him with a more serious crime. That's wonderful, if that's your political orientation. But then, I'll believe this when I see it. Okay.
Yeah.
I'm not taking anything at face value.
Yeah.
Let me see what indictment they do or do not return. You agree with me, right?
No, I do. Well, because we just don't know what those charges are going to be. They could be, more serious, less serious. They could be entirely different. So we just have to wait and see. Yeah. We have to wait and see. Yeah. Doug, while I have you, I want to move away, though, from the Hunter Biden stuff because there was some kind of minor developments today down there in Fulton County, Georgia, because September 6th, today was the day that the arraignment for all 19 co-defendants took place. And we know most of those defendants waived the indictment and pleaded not guilty, meaning they didn't have to show up in person today. Specifically, I think this is interesting, though, Doug, because a lot of the focus has been on former White House Chief of Staff Mark Meadows and his efforts to remove the case to federal court from state court. Now, today, he's asking the state judge in the case to stop all proceedings against him until there's a final decision on that question, including appeals on that motion to move his case to federal court. What's the likelihood a judge is going to do that?
No, basically, when you file a petition to remove it into federal court, the case is still technically pending in state court until the federal judge indicates that he or she is going to, in fact, remove it into federal court. So I don't think Mark Meadows is going to be successful, but at the same time, it'll probably be mostly academic because I think the federal judge will rule on this relatively soon. But I want to make 2 just quick tutorial points because I'm seeing in the media a little bit of information that I'm not going to call it intentionally misleading, but perhaps uninformedly misleading. So let me just make these 2 points. Number 1, if one defendant, Mark Meadows, petitions for removal to federal court and he's successful, hypothetically, that does not remove the entire case and all the other people into federal court. The reason I mention this is because I've seen a lot of media reports left and right, which are confusing people on this point a little bit, which is, oh my God, everybody will be in federal court. Not true. Number 2, speedy trial, very important, because that's the whole political narrative. Forgetting law for a minute, will he go to trial before the election?
Right.
And everybody's all amped up. The fact of the matter is, Sidney Powell and the lawyer, Chesborough, have moved for an immediate speedy trial. That does not mean that the entire case will be tried in October.
Okay, yeah, because that was the news also today. Kenneth Chesborough, Sidney Powell, Trump attorneys,
right.
it looks like, are going to trial this October. And so that is quite speedy. And we'll see if any other defendants kind of follow suit there. But they were asking for that, right, Doug?
No, they specifically stepped forward, as is their right. And this is where it got so confusing. And you heard me explain so many times. The speedy trial right is the defendant's right. So Mr. or Mrs. defendant, and in this case, we have a male defendant and a female defendant, they are entitled to stand up and say, under the Georgia Speedy Trial Act, Your Honor, we want an immediate trial within X days. That's it. And the government, has no real say in that. The judge has to do it because it's by statute. Here, what happened was, with all of the political thirst that I've been describing to get the case to trial before the election, you have government prosecutors asking for fast trials. And I've explained calmly over and over that you just don't see that usually.
Okay. Also, Doug, I just want to bring up, because former President Donald Trump was on with radio host Hugh Hewitt today. Hugh Hewitt asked him, about all of this and essentially kind of pegged him on the question of whether he's going to, mount his own defense, meaning is he going to take the stand in his own defense? And Trump said essentially, yes, he's going to do that. He's going to be there. No doubt the calendar is getting quite busy come 2024. What do you make of that? I mean, that's to be expected, right? He can't just do this with his team of attorneys there in lieu of him.
No, I mean, first of all, call me cynical. Forget this case even. I'm just saying in general, I've been around these rodeos for 35 years. And the point is, just because he says today, September, whatever it is, 6th, that he's testifying, that means absolutely nothing. Okay, we get in these rodeos right in the middle of trials. Start the trial the first day. By the way, Mr. Burns, me as a defense lawyer now, is your client going to testify? And the point is, you get all different answers. As of right now, Your Honor, he intends to. Okay, well, guess what? Now, Your Honor, he's not going to. So it's absolutely meaningless. And I'm not criticizing anybody. Donald Trump is the master of sort of messaging. Right. So I guess he felt he wanted to get the message out. An innocent person, of course, gets up there and takes the stand. So that's just where he's coming from. But as we get down to crunch time, under save another tape, this one, I'm not so sure he's testifying, okay?
Okay. I mean, we did get a better sense, though, of what prosecutors are envisioning, timeline-wise for the trial, the number of witnesses they want to call. I'm hearing, and there was reporting today, because we're about to show some of the proceedings today in Fulton County in the courtroom, because it is televised. They were saying as much. They're going to call 150-plus witnesses. They expect it to take about 4 months of time. Is that even possible, do you think, Doug? With that many witnesses, 4 months? I mean, just jury selection alone.
Yeah, once again, what I bring to the table is, years of experience. And very often those estimates are, way more. I'm not saying that's the case. I don't know. But, very often people say the trial's going to take 6 weeks, Your Honor. And they say it in good faith. And then it turns out the trial's 1 week or 10 days. I've seen that a million times. So very hard to say. I don't think there was any real motivation to sort of puff the chest out and say, we have 150 witnesses. So, we'll see. I don't think the case would take quite that long, but you never know. I mean, the O.J. Simpson case should have taken 6 weeks and it took 6 months. So you tell me what happened there.
All right, Doug Burns, as always appreciate these discussions here because no doubt so many people are also talking about it just like you and I, and we'll definitely be bringing you on again. Thanks so much, Doug. My pleasure. Thank you, Andrew. Okay, so we want to stay with this topic, though. We always thank Doug for his expertise and insight, but our friends at Fox 5 in Atlanta looked at the case of Sidney Powell and Kenneth Chesebro kind of under the microscope because they are going to trial this October, just like Doug and I were describing. So we want to play this report out for you about what that's going to look like.
All right.
And with that, Fulton County made history, the first televised hearing of any of the election interference cases. Sidney Powell and Ken Chesebro asked for speedy trials, but they don't want to be tried together, arguing their alleged crimes have nothing to do with each other. Powell's charges involve the security breach of voting machines in Coffee County. Chesebro, the so-called fake elector scheme.
What he's accused of has absolutely nothing to do with Ms. Powell at all.
How, Your Honor, is the plan down in Coffee County, if it's a plan, the alleged plan, have any commonality other than electing Donald Trump?
While, Mr. Cheeseborough may have never been to Coffee County, because it's a conspiracy case, Mr. Cheeseborough is liable for what happened there.
Prosecutors argue because all 19 took part in the criminal enterprise, they should all be tried together next month. All 19 defendants, including former President Trump, even though he and the others did not file a speedy trial motion. The idea, prosecutors said, is to save time.
The state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same.
A trial, he said, that would take 4 months once a jury was selected and involve 150 witnesses, not including any defendants who may testify.
We plan to make that October 23rd trial date stick.
Judge Scott McAfee seems skeptical about forcing all 19 to go to trial next month, but at least 2 will be tried together.
I'm not finding the severance from Mr. Chesbrough or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case.
All right, we thank Fox 5 Atlanta for that report there. So this is shaping up to be quite interesting. I know there's a lot of moving parts to this story, especially this indictment there in Fulton County. There's a lot of defendants, of course. There's a lot of charges, and we'll do our best here to make it make sense for you. We know it's complex and complicated.